Hello, good evening. Can you hear me? Hello?
Yes, sir, we can hear you.
Uh, also, I Cosmate. I don't know whether we are doing, and I just joined. I don't know whether we are using this link today. I'm Emmanuel.
Even me too. I'm hoping that we will use it.
That's okay. I could not attend the physical class, so I just said, let me check whether the like. I just heard that it's only 5 of them that is inside class now, so I thought, let me just join this one to know how far.
Mm, no, it is well.
Let's open so that I don't know whether the lecturer can say let you use both the physical and virtual. It could be better for us because where I am now is far.
Hello, good afternoon, Mr. Emmanuel. Welcome to this class.
Good afternoon, ma.
In the past, it was online classes throughout for Professor Olanio's um, um, courses, and
Okay.
and that's also preferable by Professor Olanio. And I believe one of the reasons why they were not, anyways, until the new rule came. And the new rule is that there must be 70% physical lectures and 30% online lectures. Now, the reason
Okay.
why I spoke up is this. Mr. and Professor Lanier is just being kind
Wow.
to conduct online classes. And lately, what he has been doing is that when there are not many people in class, he would activate the Zoom link where people
Join.
can join online. However,
Mm. Hello, ma. I'm with you. This network, I can hear you clearly.
won't use that as an excuse so that it doesn't look as if we're abusing the privilege that we have.
Okay,
It's
sir.
one of
Okay.
the
Okay, ma.
few lecturers who do this. One of the few
Okay.
of them. All right.
Yeah.
Thank you very
I really
much.
appreciate.
Okay.
I really appreciate for your explanation. God bless you, ma.
God bless you too. Thank you. So let's be hopeful that since it's in class now, let's be hopeful that at some point it would ask for this to be activated so that we
Okay.
can also participate.
Okay. Thank you, ma. Thank you, ma.
All
I
right.
really
Thank
appreciate
you.
it.
Okay.
Okay.
So, how many are you in the group? Why are you the only one? Who are the others? Okay. Is it the only one that will present everything, or you have an array? Okay.
Personal systems of law and legal pluralism in Nigeria. To put justice to this topic, we divided our paper into about 8 parts. Where we have the introduction, we have the historical development of legal pluralism in Nigeria, where we consider the colonial era, and post-colonial era. Then we also have the personal systems of law in Nigeria. These are customary law, Islamic law, and statutory law. Then we also look into legal pluralism and its challenges. And some of those challenges that we look at are jurisdictional conflicts, disparity in gender rights, constitutional supremacy as against religious autonomy. Then we also look at lack of codification. Then we consider legal pluralism in practice, when we compare, when we look into family and personal law, criminal law, as well as land tenure system. Then we also touch comparative analysis of legal pluralism, especially in common law jurisdictions, to try to compare Nigeria and South Africa. Then we look at reforming legal system, legal pluralism in Nigeria. Then we conclude our paper and also compare recommendations. So this paper examines the interplay of personal system of law and legal pluralism in Nigeria. It explores the historical evolution of legal pluralism, the interaction between customary law and Islamic law, and statutory law, and the challenges of harmonizing these systems within a single legal frame. Then the paper concludes by proposing reforms to enhance the existence of this legal system while ensuring justice and equity. Now we know that Nigeria is a multicultural, multi-religious society and operates a plural legal system where multiple systems of law coexist. So we won't be able to do that when you go through our paper, you get to understand what I'm saying. But without taking much of your time, we'll look at the historical development of people rising in Nigeria. As I mentioned earlier, the colonial era, what colonization, sorry. Indigenous customary law govern local communities in Nigeria, and these laws were largely unwritten. They are flexible and they are deeply rooted in traditions and customs of the ethnic populace in Nigeria. Now, the colonial northern region was also predominantly influenced by Islamic law, which was introduced through trade and, of course, scholarship. Then we didn't really dwell much because we would not want to bore you with all that. We moved straight to our colonial era. Then in the colonial era, we are talking about the advent of the British colonial rule, which occurred in the 19th century. Now, the colonial authorities adopted a policy of indirect rule, allowing the custom and Islamic law to coexist with English law. However, statutory law was deemed superior, particularly in criminal and commercial matters. During this period, English law was introduced primarily to facilitate administration of justice in commercial and criminal cases involving Europeans. Customary Islamic law were relegated to personal and communal issues, creating a hierarchy structure within the legal system. The British established native courts to administer customary and Islamic law, but these courts operated under the supervision of the colonial officials. Then let's look at the post-colonial era. After independence in 1960, Nigeria retained its plural legal system. The 1999 constitution recognizes customary and Islamic law alongside the statutory law, creating a framework for their application in various spheres. Including personal, family, and criminal law. We refer you to section 6.5 of the Constitution. That section shows that the Constitution recognizes customary, Islamic, and even the statutory law. So that's what we are trying to say in that aspect of our paper. Then let's look into the personal system of law in Nigeria. As we mentioned, the customary law. The customary law deals from traditions, custom, and practices of Nigeria's various ethnic groups. It governs matters such as marriages, inheritance, and land ownership. It is a very dynamic and very significantly across regions. In southern Nigeria, for example, the Yoruba and Igbo customary laws emphasize patrilineal inheritance, while some communities in Niger Delta recognizes matrilineal systems. Customary law reflects the collective identity and values of the community. It prioritizes communal interests over individual rights, emphasizing obligations to family and community. Then let's quickly go to Islamic law. Islamic law, the Sharia law, applies predominantly in the northern state of Nigeria, where it governs personal matters such as marriage, divorce, inheritance, and in some states, criminal law. The introduction of Sharia penal code in the early 2000s sparked debate on its compatibility with constitutional provision. The integration of Sharia into Nigerian legal system highlights the country's commitment to accommodate its diverse population. As we mentioned earlier, that the Constitution of Nigeria recognizes these various system of various legal system. So, without spending much time on that, we quickly move to statutory law. And of course, statutory law comprises those laws that are enacted by the Nigerian legislation, because it is mainly influenced by the English common law and governs areas such as contract, torts, constitutional matters, and vis-a-vis. It aims to provide uniform legal framework applicable to all citizens. And one of the significant features of the statutory law is its reliance on codified rules and principles. They are mainly codified, unlike what we have in the customary laws, which are mainly on written and other. Statutory laws are codified. Example of such laws, we have laws of Matrimonial Causes Act, we have the Child Rights Act, and some of these law often conflicts with customary and Islamic law. For example, statutory provisions on child custody or marriage sometimes challenge cultural norms, leading to legal disputes. that require judicial intervention to resolve. Let's quickly proceed to legal pluralism and its challenges. Now, legal pluralism in Nigeria presents unique challenges arising from the coexistence of multiple legal systems. These challenges manifest in various forms, including jurisdictional conflicts, gender disparities, constitutional contradictions, and of course, lack of codification of customary law. So these challenges, we will look at them one after the other. The jurisdictional conflicts. Now, this occur when two or more legal systems claim authority over the same matter. If we have a matter where Islamic law is claiming more authority over that matter, and same matter, customary law applies to it. So that is what we are trying to say here. And this particularly is common in family law, inheritance, land disputes. For example, a marriage that is conducted under customary law may face legal challenges if it does not meet statutory requirements, leading to dispute over its validity. How do we solve it? Usually, taking the position to cure these challenges. And one of which is in the case of Anekwe versus Nekwe. And that case is reported under 2014 Law Tribunal Electronic Law Report 2267, the Supreme Court case. In that case, judiciary demonstrated its role in addressing divisional disputes and advancing equitable outcome. Now, the Supreme Court invalidated a customary law that is practiced. That such practice is that it prevents women from inheriting family property. And holding that such a practice was discriminatory and contrary to Section 42 of the 1999 Constitution. The decision highlights the judiciary role in resolving judicial conflict by ensuring that customary law aligns with constitutional provision. It underscores the supremacy of the Constitution while affirming the need to respect cultural law. Another source of jurisdictional conflict is the implementation of Sharia law in other states. While Sharia law governs personal and criminal matters within Muslim communities, its interaction with statutory law often leads to legal uncertainty, especially in cases involving non-Muslim or interfaith disputes. Another challenge is disparity in gender rights, as I mentioned earlier. Customary and Islamic law often disadvantage women in such areas as inheritance, marriage, and child custody. This disparity conflicts with constitutional guarantee of gender equality and human rights. For example, under customary law, women are excluded from inheriting property, as I mentioned in that particular case. Now, the Nigerian Constitution prohibits discrimination on the ground of sex, providing a legal basis for challenging gender disparity. The case of Mojeku versus Mojeku illustrates the judiciary role, of course, in addressing gender inequality within the frame of legal pluralism. In that case, of course, the Court of Appeal addressed the discriminatory Nnewi customary practice of Olekwe, I'm sorry if I didn't pronounce that very well, which deny women from the right to inherit property. Now, in that case, Justice Nikitobi delivered the lead judgment and condemned the practice as repugnant to natural justice, equity, and good conscience, because that such custom could not stand where they conflict with constitutional provision, guaranteeing equity and non-discrimination. We also look at another challenge, which is on the constitutional supremacy as against religious autonomy. The principle of constitutional supremacy is central to Nigerian legal system. Balancing constitutional authority with autonomy of personal system of law is a recurring challenge. We refer to the case of Attorney General of Kebbi State versus Bala Shagari. The case was reported in 2006 Nigeria Routine Law Report 1, Nigeria Routine Law Report, Part 961 at 318, where the court examined the conflict between constitutional authority and the autonomy of Sharia law within the framework of Nigeria legal pluralism. And the case evolved around the enforcement of Sharia provisions in a manner that conflicted with constitutional guarantees of fundamental human rights. The court emphasized in that case that while personal system of law, including Sharia, are recognized, their application must align with the supremacy of the Constitution. particularly regarding rights such as freedom from discrimination and fair hearing. Another major challenge is lack of codification, as I mentioned earlier. One of the most significant challenges in Nigeria's legal plural system is lack of codification of customary laws. Customary laws are primarily oral traditions passed down through generations, which makes their application inconsistent and subjective. Now, the absence of formal documentation, which leads to dispute over the exact content and scope of this law. I think we've overflowed that particular issue on lack of codification. Now, the last but not the least of the topic I'll be discussing is the plural legal pluralism in practice. Of course, legal pluralism in Nigeria is most evident in its application to personal law, criminal law, and land tenure system. These areas highlight the dynamic interaction between customary Islamic and customary law and statutory law, as well as the challenges of the counseling this system in practice. We made reference to family law and personal law. We also cited the case of Mojeku versus who was stated earlier. And what we are trying to say is that we are looking at the role of customary law and the role of Islamic law in these various areas that we mentioned, the family law and personal, as we talk about marriage, inheritance, and all that. We also look at criminal law, where we say that criminal law in Nigeria illustrates the coexistence of statutory and Islamic law. While statutory law governs criminal offences nationwide, Sharia penal codes apply in northern states, creating a dual legal system, in Nigeria, as the case may be. Statutory law is codified in criminal code, applicable in the southern Nigeria, and penal code is applicable in northern Nigeria. We all know this. So then let's quickly proceed to the land tenure system. Land tenure system in Nigeria exemplifies the complexity of legal pluralism as they are governed by a mix of statutory laws, customary practices, and Islamic principles. Of course, the Land Use Act of 1978 serves as the primary source statutory framework, placing all land in the hands of the government to be held in trust for the people, the governor, as the case may be. So, without taking much of our time, I would like to call the next speaker, who is going to dwell on comparative analysis of legal rights in common law jurisdiction. And in doing this, he's going to compare Nigeria and South Africa, which are both common law countries. Thank you.
Thank you very much. Thank you very much. My name is Adidayo. In this section, I will be looking at or describing the comparative analysis of legal pluralism in common law jurisdiction. And when we say common law, we are looking at Nigeria and other countries which are being colonized by England, so to say. So in common law countries, we will ordinarily want to compare Nigeria, South Africa, and probably India, but because of the time, we couldn't capture the Indian aspect of it. So in this comparison, we will be looking at Nigeria and South Africa in some aspects. So in the legal system, legal pluralism in Nigeria and South Africa, what are those similarities in the real sense of it? One, we have virtually the same colonial master or colonial legacy, and this involves where both Nigeria and South Africa have a colonial legacy that has been influenced by their legal system. Both countries have mixed tradition, customary, and Western law. And number two, we have multi-ethnic and multilingual society. And by so mean, we said both countries have multi-ethnic and multilingual with many different traditions and customs. Also, in recognition of customary law, the Nigerian courts and the South African courts both recognize customary law as a valid source of law, although the extent of recognition varies. Like in the case of Elena versus Ayere Haika, I'm sorry if I didn't pronounce the name very well, where a plaintiff is a childless woman got married to another defendant who is a woman in their tradition. When she was told to be the mother of the children, which she didn't give birth to, the defendant to the plaintiff's knowledge became pregnant for another man in their village. The plaintiff paid all the antenatal bills and postnatal bills and named the child at birth. However, when the father of the child relocated to another village, which the child the plaintiff instituted proceedings for return of that child. The appellate court in Nigeria held that it is an odious custom to permit a woman to marry another woman in Nigeria. It is equally outrageous and against public policy to deprive unwilling natural biological parents for any reason of their child and best sin on a childless parent or childless man or woman as if the child were a chattel. In this case, the custom. So therefore, in this case, this custom was held to be unenforceable because it is repugnant to natural justice, equity, and good conscience. However, the position of Nigerian courts may not be applicable in South Africa, where same-sex marriage is legalized. For example, Section 1 of the Civil Union Act of 2006 in South Africa recognizes this same-sex. It legalized same-sex, and in that section, it provides that marriage is the voluntary union of two persons who are 18 years of age or older, which solemnize and register by way of either marriage or civil partnership. So the court in Nigeria, which held that marriage of the two women is illegal, this same position may not be applicable in South Africa as regards if we make reference to the Civil Union Act, Section 1 of South African law. Fourthly, will be the coexistence of different legal systems. In Nigeria and in South Africa, we both have multiple legal systems coexisting, which includes the traditional, customary, Islamic, and even the Western law. So let's quickly look at the differences. The first one we'll be looking at is the constitutional framework. What is the difference between constitutional framework of Nigerian constitutional framework and the South African framework? South Africa has more comprehensive constitutional framework that recognizes and protects customary law, while Nigerian constitution is more limited in its recognition of customary law. And if you look at provision of Section 211 of South African Constitution, which protects customary law, this section recognizes the importance of customary law and provides for its application and development in a way that is consistent with the Constitution and the Bill of Rights. However, in Nigeria, we have Section 273 of the Nigerian Constitution, which does not explicitly protect the customary law. However, Section 274 of the Constitution mentions that nothing in this Constitution shall invalidate any customary law or any derivation of native law and custom of any ethnic group in Nigeria. So these are the differences. Number two, customary law courts. In South Africa, it is well established. They have a well-established system of customary law courts. While in Nigeria, Nigerian law courts are less formalized in recognition. And we said that on the strength that if we look at the Section 287 of the 1999 Constitution, it provides that the decision of the customary court of appeal of a state shall be accorded the same recognition and privileges as the decision of the High Court of the state, which shows that although both recognizes the customary law courts, however, the South African courts are more enshrined in their laws, in their statutory provisions. Number three, Islamic law. Nigeria has more extensive system of Islamic law with Sharia courts in many northern states. Just like my colleague said earlier, that where we have Islamic law is much dominant in the northern states of Nigeria. While in South Africa has a smaller Muslim population and less extensive Islamic law system. Number four, we have traditional leadership. In both systems, although we have recognition of traditional leadership, however, South Africa has more formalized system of traditional leadership with recognized traditional leaders and councils, while in Nigerian traditional leadership system is less formal, much more depending on the state. Now, number five, we have legal pluralism policies. In South Africa, South Africa has more explicit policies and laws promoting legal pluralism, such as the recognition of customary marriage acts. They have what's called customary marriage act, while in Nigeria it is less explicit. Note, however, that where Nigeria and South Africa share the same similarity in legal pluralism framework, there are significant differences in their constitutional framework, the customary law courts, the Islamic law system, traditional leadership, and policy promoting legal pluralism. Both countries also face the same challenges in harmonizing laws to ensure access to justice and capacity building. Now, let's look at legal pluralism in marriage in Nigeria versus that of South Africa. What are the similarities? Number one, we have recognition of multiple marriage systems in both Nigeria and South Africa. Both their laws recognize what is called multiple marriages, like polygamous marriage. Both Nigeria and South Africa recognize multiple marriage systems, including customary, Islamic, and civil law. And to that, we look at Section 36 of the Marriage Acts in Nigeria. In Nigeria, it recognizes customary marriage, which may involve polygamous, which may involve polygamy. However, also, we have Section 277 of the Nigerian Constitution, which provides for the establishment of Sharia Court of Appeal, which may apply to Islamic law permitting polygamy in Nigeria. While in South Africa, Section 15, subsection 3A of the Constitution recognizes the right to marry in accordance with one's culture or religious custom, including polygamy. That is what is provided. So they both share same similarity as regards recognition of multiple marriage system. Number two, we look at coexistence of different laws. Both South Africa and Nigeria have different law governing marriage, including customary, Islamic, and statutory law. Number three, we have the importance of traditional and cultural practice. Both Nigeria and South Africa place significant importance on traditional and cultural practices in marriage. But what are the differences in this sense? Number one, we look at the constitutional framework in South Africa. South Africa Constitution explicitly provide or recognize and protect customary marriage, while in Nigeria, Constitution is less explicit. Number two, we look at customary marriage laws. In South Africa has more comprehensive framework for customary marriage, including recognition of Customary Marriage Act, which is an existing law there, while Nigeria's customary marriage laws vary state by state. And number three, we look at the Islamic marriage law. Nigeria has most extensive Islamic marriage law, with Sharia courts in many northern states. Even about some few months ago, there are propositions to bring it to the south and agitations. While in South Africa has smaller Muslim population and less extensive Islamic marriage laws. Number four, we have registration requirements. Registration requirement for marriage in South Africa requires registration for customary and Islamic marriages, while in Nigeria, registration requirements vary state by state. So let us look at gender rights. Legal pluralism in gender rights in Nigeria versus South Africa. Number one, in terms of similarities, we look at the recognition of multiple legal systems. Both Nigeria and South Africa recognize multiple legal systems, including customary, Islamic, and even statutory laws, which impact gender rights. And number two, we look at the patriarchal society, in both South Africa and Nigeria. Patriarchal society, where traditional and cultural practices often perpetuate gender inequalities. And lastly, we look at gender-based violence. Both countries, that is Nigeria and South Africa, face challenges in addressing gender-based violence, including domestic violence, rape, and female genital mutilation. When we look at the differences in terms of gender rights, the Constitution South African Constitution has a comprehensive Bill of Rights that explicitly protects women's rights and gender equality, while Nigerian Constitution has more limited provisions. Likewise, we have number 2, which is customary law. Nigeria's customary law is more pervasive and often conflicting with statutory laws, while South African's customary law is more formalized and recognized without much contradiction. Now, number 3, we look at Islamic law. Nigeria has more extensive Islamic law with Sharia courts in many states, just like we said earlier. Number 4, without wasting time, we have legislative reform. South Africa has enacted more comprehensive legislation to address gender-based violence, such as Domestic Violence Act and Sexual Offences Act, while Nigeria's legislation reforms are more limited. Let us also look at legal pluralism in property rights in Nigeria versus that of South Africa. What are the similarities? Number 1, we have the recognition of multiple legal systems. Both Nigeria and South Africa recognize multiple legal systems, including customary, Islamic, and statutory law, which impacts customary rights. In Nigeria, Section 43, for example, of the 1999 Constitution guarantees the right to acquire and own immovable property anywhere in Nigeria. Likewise, the Land Use Act of 1978 regulates the use and acquisition of land in Nigeria. The property and conveyance right also governs the property transaction and conveyance. However, in South Africa, Section 25 of the South African Constitution guarantees the right of property, including right to own, acquire, and dispose of property. In South Africa also, we have the Property Rights Act, and these are many laws, one of the many laws in South Africa that guarantees property rights in South Africa. In terms of differences of the property rights, the constitutional framework in South Africa has more comprehensive bill, like we said, that explicitly protect the property rights, while Nigerian Constitution has more limited rights. And in terms of that, we look at the South African Constitution and laws, which provide more explicit protection of property rights, rather than Section 25. Than Nigeria, Section 25 of South African law, 1996, explicitly provide for number 1, no one be deprived of property except in terms of law of general application, or no law may permit arbitrary deprivation of property rights. Number 2, property may be expropriated only in terms of law of general application. And many like that without wasting much time. Please go. Yes. So we move to what is called reforming legal pluralism in Nigeria. And we will be looking at 4 segments of this. 1, codification of customary law, judicial training and interpretation, and we also have constitutional amendments. And lastly, we'll be talking about public awareness and education. Now, codification, most of our laws in Nigeria are not codified. So the codification of customary law is the first step in addressing the challenges of legal pluralism. And for the sake of time, I want to check the material. Public awareness, which is the last one. And in conclusion, the interplay of personal system of law and general legal pluralism in Nigeria reflects countries' rich cultural and religious diversity, while the pluralism accommodates the unique identity of various communities. It also presents significant challenges in ensuring justice, equity, and adherence to constitutional principles. So the success of Nigeria's plural legal system depends on the willingness of the stakeholders to engage in dialogue, embrace reform, and prioritize the common good of all. With concerted efforts, Nigeria can transform its legal pluralism into a source of strength and unity. I'll make some recommendations, first of which is there should be codification of the customary law. Number 2, we have judicial training, some of companies of law, and we look at the constitutional reforms and amendments if possible. And we talk about recommending public legal education. Likewise, the Organic Institution and Gender Equality Act enhancement, access to justice, enhance access to justice, monitoring and evaluation, and promoting the interfaith and intercultural dialogue. Thank you.
What are the other two? What are the other two? What step for?
We also participate.
As long as when we want to attend the paper now, we'll give you a call back. Anyway, so the paper has been presented. Can I have your comments? Can I have your comments, please? Comments and questions for the presenters. Yes? Yeah? But the paper was sent to you earlier. And we went through the paper.
I think they've done a good job. So the question I have for him is respect to the recommendation again. And he said we believe customary law in the codified. So I want to ask him what the basis for that, because I know customary law is maybe it's not something that certain every point in time. So I just want to
It's not what?
it's really it's not certain at every point in time. Can you address your question clearly? You are quoting one of the formulations that we made, which has to do with codification of the customary law, and you stated that customary law is evolving. That's what you're saying, and that codification of a law or a principle or a rule that is evolving is not very difficult. I start to disagree with you that it is evolving, because I believe it's a norm that is known by people in that particular culture or settings. Are you getting it? But because they know this particular rule and it is always there, but the problem is that it's unwritten, and due to the fact that it's unwritten, there may be one or two modifications as time goes. You understand? As time evolves, so one or two things will come in that will change those particular rules or customs. Are you getting it? But if there is codification of those particular customs, then you can't just wake up one day and start changing something. Are you getting it? So I think it's going to be more of an advantage if it is codified, written down. For instance, a custom that says that a woman cannot inherit the property. Are you getting it? And they say that and probably maybe in the next 10 to 15 years time to that period, another person will come and say, okay, actually what they're actually saying is that it's the first daughter that cannot inherit, or the second daughter that can. But the general custom is that a woman cannot inherit. But somebody might just come, why is it written down? These are custom and tradition, and we have it documented. And it's saying that a woman, either first daughter or second daughter or third daughter, cannot inherit it. It is there, they can produce it.
Okay. Let me dive into that argument. You see, when we discuss codification, it has advantages and disadvantages. Both of you are arguing, you stating the advantage, he stating the disadvantages. The biggest problem with customary law is proof. Okay? So to prove customary law, because the court are not experts in customary law. Even if they are experts, they will only know the customary law predominant in the community where they exercise jurisdiction. So most of the time, you need chiefs, respected members of native community. Occasionally, when books have been written, the books will be presented and all of that. Okay? When you codify, codification is very identical to legislation. When you codify, you make many things certain. Okay? But the disadvantage of codification is what you had mentioned. Because one of the characteristics or alleged characteristic of customary law is flexibility. So once you put something down in black and white, you may not, as often as there is a change in position, be able to amend. And people will continue to rely on that black and white as position of the law. Writers demonstrate that times were when the mere fact that the transactions between two people was made in writing was enough for the court to say, no, this could not have been governed by customary law. Customary law does not know writing. Okay, but as time went on, education became democratized, and even people in native community now became able to read and write. You no longer could say that simply because something was written could not have been governed by customary law. So those are the effects of changes that will occur to custom as the community where the custom apply embrace modernization or civilization. And if you codify the custom, you might miss all of those opportunities or make it even more difficult to show that custom has changed. So when there is both of you are saying, what both of you are saying is correct. It's just like the pros and the cons of the customary law system, of codification of the customary law. Okay. So, any other comment? Yes.
Just in my mind, while you were speaking, I think that a serious area of conflict or legal pluralism under Nigerian law with respect to marriages, for example, might come up when somebody is challenging the validity of the marriage or proposing the nullity of the marriage in court, statutory marriage. And the basis is that they sustain customary law marriage. Now, without codification, or let me say, for example, registration of customary law marriage, the existence of the customary law marriage depends on the validity of the statutory marriage. So if customers don't register their marriages, maybe there's no registration board that issues certificates for customary marriage, then there's a major conflict as to which law should apply. So I think it is in the area of dependence of validity of statutory marriage on customary marriage that issues like codification or recognition of customary marriage might now make a lot of sense. And that was on the one hand. On the other hand, just like statutory law, customary law evolves. So there's nothing stopping customary law from being codified if in the future there's any need to amend it in tune with the current reality, as against just putting it at the back bench and saying that there's no need for
the issue with customary law is that it's not made by a lawgiver. Not made by a lawgiver. It is the practice and usage of the people, and it will change with the outlook of the people. Do you understand? So having it in writing might reflect the position of yesteryears. Okay? But proving it in individual case might present before the court the updated version. Do you understand? Look at, if you want to understand the problem with codification, just look at TKC declarations. TKC declaration is one good example of codification of rules of custom. Okay? So, what does it do? It helps to prevent debate and arguments. Okay? But whatever is it about those rules that were not captured at the point of the declaration, presenting them later becomes very difficult. And then, if those who are connected with the chieftains, if we say the custom is flexible, there's no reason why they're not changed. But if you have recorded it down, okay, the person who is saying the custom remain as it was will most often win a debate about what is the current custom of the people and all of that. So I did not get your gist about how codification will help conflict of marriages or internal conflict of marriages. I do not get your point, but what I know is that internal conflict of marriage law is, insofar as the issue is conflict between statutory marriage and non-statutory, does not really exist, because the Marriage Act has set out the requirements for statutory marriage. And on the same hand, it has provided that nothing in the Marriage Act, okay, will nullify marriages done under customary law. So the simple answer is, if there's a compliance with the Marriage Act, the marriage is a statutory marriage, a monogamous marriage. If there is no compliance, the marriage will qualify as a customary marriage. Okay? Then talk about the issue of mutation, the double-decker issue. And the cases have also resolved that one. That what simply happens is that the customary marriage loses its independent status once the same couple, okay, have progressed their relationship into the act requirement. Do you understand? So maybe if you have marriages between persons amenable to different systems of customary law, okay, that one too, the conflict issue is not even resolved by codifying any of the two of them. The conflict issue is outside the customary laws of the two persons. The conflict issue must be formulated independent of the internal law. Okay?
The point I was trying to make is that let's say Mr. A gets married to Miss B under customary law, and subsequently contracts a marriage under statutory law to Miss C. Now, Miss B is challenging the validity of the marriage to Miss C on the pretext that they have a customary law marriage. And I'm not saying that in the event as it is under the Nigerian law, that there is no registration or some kind of certificate of validity of that customary law marriage. The success of the suit challenging the statutory law marriage will be dependent on the validity of the customary law marriage.
which, because there's no registration or codification, will need some kind of judicial notice or proof to prove that that marriage has in fact been.
So you have answered the question. The codification, that's what we are saying. The codification would have made the customary law position certain.
Yeah.
Absence of codification would ensure that you need proof.
Yes.
Okay, so we said that codification makes certain what the custom for every community or district is, but also certifying the development of the custom of that community. So it's the same thing we are saying. Okay? So, any other comment or question? These are things that they happen every day now. So, if you have read them, you should have had one thing or the other to contribute. Anybody online with comments? Okay, those ones online, they usually just want to be recorded as I'm attending. I'm not even sure they are listening. Okay.
So we are listening.
So any comment from you?
No comment, sir.
No comment, sir,
No
for
comment.
So we are listening, no comment, we are
It's all
flowing.
right, it's all right.
Comment.
You don't
the
want
topic
to
is straightforward.
Is it this topic? This legal pluralism topic is a topic we treat in jurisprudence as well as the conflict of laws. Okay? I think the jurisprudence people have taken their paper. But I think this paper is more qualified for the jurisprudence class than the conflict class. Because in the conflict class, we are more concerned with practical issues than with jurisprudential. This is a jurisprudential paper. Do you understand? Even though there are some of the things that we would have loved them to also say to make a good jurisprudence paper on legal pluralism. Okay? What is our own concern in conflict of laws? It's very simple. It's very, very simple. When we started, we told you that subject has dimension. That also, we said international, interstate, and internal.
Yeah.
Okay, that's what we said. And if you see the way we've been discussing, some people took the topic, the nature of interstate, and how it is affected by the culture of federal states. Okay, that's what we took last time. When we said you go to some federation, the interstate conflict is as serious as the international. Because states will take their autonomy seriously. And that will mean that internal laws will be different. And conflict rules will also be different. Okay? But if you now understand that internal laws are not really different, and conflict rules are inherited from England, you might then appreciate that your own interstate conflict of laws is not as serious as those of other federations. And that will influence you when you have interstate issue. So I will say that, say for example, the court of one state that is tasked to determine liability for torts that occurred in another state, or that occurred in that state involving somebody from another state. Okay? that ordinarily would have thrown up an interstate conflict of laws, because tort is a residual matter, in respect of which states could go their different way if they chose to. But the practical recognition of the fact that the states, the constituent states of our own federation do not do that, simply means that our state tort laws are likely to be the same. So what does the court do? Does the court begin to bother himself about connecting factors? Why will you have to bother yourself about connecting factors when the connecting factors will direct you to either the law of state A or state B? But the internal law of state A is the same as the internal law of state B. And so when you now study the Nigerian cases and you ask yourself the hard question, all of these discussion, double liability, let's not cheat the limited community, to achieve what? In a state with serious interstate conflict, it is to arrive at applicable law. Okay? That is because the fortune of the litigant will depend on which of the state laws you apply. Okay? But where you are sure that the laws are the same, are you not the one creating conflict by applying connecting factors to determine applicable law? So sometimes you now say, because one pleads the law of state A and not the law of state B, he will not get justice. That is not the position of that is not conflict jurisprudence. That's not what is expected in conflict jurisprudence. And we said that in conflict jurisprudence, it is up to the party who wants to benefit from the law of a particular state to plead and prove it. If he doesn't plead and prove it, the court does not say, I won't give judgment. The court simply assumes that the reason why he is not bothering to plead or prove it is because that law is not different from the law of the phone, and the court should apply the law of the phone to determine the issue. If our courts are mindful of that or minded of that, many of the decisions they churned out in the so-called interstate conflict of tort law cases, they would have turned them out because they had ended up creating problems instead of solving problems. So what we want to discuss in this class is this third aspect of it. How does it arise? And what are the issues that we are required to solve? Okay? So the way legal pluralism will be defined for purpose of a conflict class might be different from the way it will be looked at from a jurisprudential perspective. Okay? So you find people who are discussing pluralism in general, not distinguishing between multiplicity of laws or sources. Okay? And operation of more than one legal system on an issue. There are two different issues. There are two different issues. So if you come to me in a conflict class and you tell me that Nigeria is in legal pluralism because we have statutory laws, we have customary law, we have received English law, and we have Islamic law, all of them operating in our polity. You say that is the reason why we have legal pluralism, I will give you 0. Okay? I will give you 0. That's not the reason why we have legal pluralism. For you to have legal pluralism, your legal system must permit more than one system of law on the same subject. So you can't have legal pluralism on every subject. You can only have legal pluralism on those subjects where within the same legal district, okay? So territory has nothing to do with it. In the other leg, international and interstate, foreign element has something to do with it. The reason why you will be talking about interstate country is because of a connection with another legal district, which is a constituent state of the federation. The reason why you'll be talking about private international law is because of the connection of the dispute with another state of the world, another country. Okay? But this legal pluralism, you don't have those issues. You don't have the issue of foreign element because the court is probably trying to resolve a civil dispute between two persons who belong to the same legal district. But because that legal district law permits the operation of personal systems of law in that subject area. So an aspect of conflict of law has arisen that we call legal pluralism or internal conflict. It's the same thing, whether you call it legal pluralism or internal conflict, it's the same thing. And what we want to know in a conflict class is how does it arise? What are the issues usually that will be thrown up when you have such a problem? Okay? We usually, I have my own style of teaching the topic. My style is to tell you that, look, if it is legal pluralism, it must throw up one of three questions. And you do not resolve to those three questions by normative hierarchy. What do I mean by normative hierarchy? Normative hierarchy principle is the one that when two laws are conflicting, you use a formula to say that one will override the other. And the one that is overriding will be null and void to the extent of the inconsistency. That's normative hierarchy. The biggest problem that those who are not conflict experts have in these areas is that they use normative hierarchy less to resolve internal conflict or legal pluralism issue. That is wrong. That is very wrong. Okay? Normative hierarchy does not apply. On the contrary, the three questions that will arise is one, the question of amenability. Because you have more than one system of law operating on the same subject, and the court is faced with the task of resolving a dispute in that subject area where it has to determine which of the two or more personal systems of law will apply. So there has to be a rule of amenability. That is, who is amenable to which system and who is not amenable to it. That's the first question. Okay? To determine amenability, you have to determine the the basis of the pluralism itself. Why do you have pluralism in particular subjects? Usually it is because the legal system are choosing to give effect to characteristics that distinguishes between people of the same territory. What are those characteristics? Okay. To understand what you are saying, go and get all the legal pluralism, not the conflict of law text. Okay, get his book on legal pluralism. I think it's chapter 12. Okay. Professor Agbede distinguishes between what he calls personal law and what he calls personal system of law. What is the difference between the two? The personal law is referring to a territorial law that people or propositors will be allowed to carry themselves as they move. Usually in some subject areas. Those subject areas are the areas we also call area of law of personal status. Okay? So when you talk about area of law of personal status, you talk about such issues as a person's marriage, a person's status as whether legitimate or illegitimate. Inheritance of a person. You know, inheritance is not the right of the heir, it's the right of the owner of the property, the deceased owner of the property. So, how do you inherit a person? It's a function of his personal law. Okay? How do you distribute his estate? It's a function of his personal law. Okay? His capacity to do a will. What can he give and what can he not give? It's also supposed to be a function of his personal law. And this personal law that we are talking about is supposed to be the law of a particular state. Okay? Which in community of laws is permitted to take with himself. So the man's issue, the man's inheritance is being determined in Ghana. You will not apply Ghanaian law to determine who inherits. You apply the law of the territory you have attached into. Okay, depending on the connecting factor you are using. If you are using domicile, then it is the law of the domicile that will carry with itself. So that's why in conflict of law we say the succession to the movables of a disease is governed by the law of its last place of those. So a court in Nigeria will not be applying Nigerian law if the man is known to be domiciled statewide. A court in Nigeria applying our company to will be applying the law of statewide because the subject matter falls within the area of personal status and the connecting factor is domicile. So that is what we call personal law. Okay? Personal law falling largely in the subject area of personal status are those subject areas where when once you have attacked a person, a particular territory, irrespective of where cases are going on, you apply the law of that territory to it. And countries use different tests for their attacking. Some will use nationality, some will use residence, some will use habitual residence, but common law countries, including Nigeria, we use domicile to do that connection. Okay? But some of the time, the law that will be applied to the propositors will not just be the territorial law. It will be a personal system of law. It will be a personal system of law. So what is the difference between personal law and personal system of law? The personal system of law is based on some personal factors which two persons coming from the same territory may not share. And it is because whatever country, whatever territory we call a legal pluralism, permits that to happen between either residents or domiciliary or national. That is why we are calling that country. Now, that country may not permit it to happen across subject area. And that is why you cannot discuss legal pluralism as if it is something that operates in every subject area. You must identify the subjects where you have legal pluralism and subjects where you don't have. Okay? So, insofar as the subject is one where those personal characteristics or personal factors is allowed to differentiate between two people who are otherwise equally amenable, who are otherwise equally attached to the territory. You say that in that legal district, legal pluralism operates in that subject area. Okay? So what are those personal factors that bring about personal systems of law? The first one is ethnicity. So like they have demonstrated, if the legal system of a particular legal district decides to preserve ethnic and cultural differences by allowing people to be amenable to their ethnic customary law, then in that territory, there's a legal pluralism in those subject areas where that is allowed. And the basis of the legal pluralism, or the basis of the operation of personal system of law, is ethnicity. Then you can have religion too. Okay? It is not all religion that say you give unto Caesar what is it, and you give to God what is it. Even the ones that say so is a pretense. Yes, I can tell you that there is no religion that actually does that. All religions try to affect life by prescribing rule, either prescribing something that you say ordinarily does not concern them about family life, about business life. We have seen religion dabbling into interests. Okay? And the fact that they take different positions does not mean that whether or not to collect interest has not become a question that is affected by religious legal practice, religious legal habits. Okay? Then you find religion taking position on the right to take a second wife or third wife of the main spouse, and so on and so forth. So you will then be able to have legal pluralism on the basis of religion if people who belong to those type of religion that prescribe conduct that has legal consequences live in that community together with people who are not members of that religion. So religion becomes a basis of operating personal system of law. The third basis is race. You can have a legal district where the difference in color of the skin is recognized, and certain laws would apply to people on the basis of the color of their skin. So any subject area where laws apply to people on the basis of the color of their skin is a subject area of legal pluralism in that legal district. And the basis of legal pluralism in that legal district would then be race. Okay? So you have personal systems of law that is based on race, but it's within the same territory. There's no foreign element. That's the difference between it and the other two legs. The other two legs, there is foreign element. The real reason why there is conflict is because of connection with another state or another country. But in this one, there is no connection. There is no foreign element. It is the legal system of its own in recognition of those peculiarities, which is allowed to be operating in the legal system that has accepted that legal pluralism will operate. But now, having said that, legal pluralism will not operate in every subject area. So, I think the first thing is, if you say that you have the internal conflict or legal pluralism dimension of conflict of laws in your country, you should identify the basis and you should identify the subject area. Okay? So a jurisprudence class will just say, what are the three laws that are operating in our pluralism? That's the approach. Statutory law, customary law, Islamic law. For a complete class, we identify the subject area where pluralism could possibly operate. Okay? And that is not going to be too far-fetched because you have started by identifying what is personal law. And we have said that the difference between personal law and personal system of law is the yardstick of attachment, not generally the subject area of operation. The yardstick of attachment of personal law is territorial. They are connected with the territory. And that's why the law is applicable to. But the yardstick of application of personal system of law are purely personal factors that the legal district has permitted to operate in its treatment of people who are connected with their territory. Okay? It then becomes very easy to identify the subject area. The areas are largely the same subject areas of personal law. Okay? So it will operate in the area of marriage, it will operate in the area of matrimonial persons, custody and guardianship, legitimacy, legitimation, succession, capacity to make will. But in the very interesting scenario of Nigeria, it also operates in when the legal system permits an analogous transaction. What do I mean by analogous transaction? Sometimes the statute will regulate the subject. When the statute regulates the subject in a purely territorial manner, what do we mean by saying a statute regulates the subject in a purely territorial manner? It means that it's giving no room for those same personal factors that gave rise to legal pluralism. So you can't possibly have legal pluralism in that subject area. The example I normally give is the case of hire purchase. You know that the Hire Purchase Act, it regulates, it doesn't regulate all hire purchase transactions, if I remember. I think it regulates hire purchase of motor vehicles. Is that not so? Hire purchase of motor vehicles and other hire purchase of a given value. Go and look at your hire purchase act. Okay? So, and in regulating it, it doesn't defer to any customary or Islamic law. So what it has done is that it has regulated the hire purchase of that subject area, hire purchase of motor vehicle in a territorial manner. Nobody can come to court and tell the court that we enter into the hire purchase of the motor vehicle under customary law. Statute regulates the matter, and it regulates the matter in a territorial manner. It didn't give any room for personal factor. So you will see cases where we see two natives have entered into an hire purchase transaction. They want to use presumption under the High Court laws to say where two natives have entered into transaction, there's a presumption that customary law will apply. Unless that presumption is reported, it's shown that they specially agreed and all of that. So we have a case, there's a case where I don't know whether it is Okoli and Igbo. If you remember your internal conflict discussion in the Igbo system, that was the case where the court said, well, both Okoli and Igbo are natives. And they say that when motor vehicle is not known to native community. They say, why are you struggling with logic? The simple answer is that hire purchase of motor vehicle is governed by the Hire Purchase Act. And the Hire Purchase Act regulates the matter in the territorial manner, giving no room for personal assistance. Now, contrast that with marriage. The Marriage Act. Would you find under the Marriage Act, after the Marriage Act has done all of its prescriptions, would you find the provision saving customary marriage? So that means, though there is a statute, the legislature reserves personal assistance. You go to land law, or you go to contract. You talk about form of contract. And you find the provision that there must be a note of memorandum of any contract related to land. But what does the legislature quickly do? You quickly exempt customary. If If the land transaction was under customary law, the legislature exempts it. It means the legislature did not regulate the matter in a territorial manner. The legislature has recognized legal pluralism in that subject area. So that is how you construe statute. That's how you relate statute to the issue. Okay? If the legislature does not want the subject area regulated by statute to be affected by legal pluralism, it does so by being silent about the existence of laws that would otherwise have been derived from religion or ethnicity. So when the legislature regulates a matter in a territorial way, it indicates that there is no legal pluralism in this subject. So if you use that formula, it becomes very easy for you to know which and which of our subject area does do legal pluralism operate. The whole gamut of our public law, there's no legal pluralism there. Well, except the subject area of criminal law. And how did the subject area of criminal law become a matter of legal pluralism? Very simple. The colonial masters, when they came, they meant that no matter how bad it is, there were systems of customary criminal laws. They were not happy with most of those systems. Even up to today, you will be able to pick fault based on human rights consideration. Okay? For example, those systems might have procedural rules that say somebody cannot be harmed. They might have procedural rules that say that somebody cannot be harmed in his defense. Okay? Or that somebody of a particular sex cannot give evidence, which the colonial master would think is not all right. Okay? Then the punishment that those personal system of criminal law impose were sometimes considered violative of human rights. None of that. So what did the colonial master do? What the colonial master did was to support the sentiment of the people and try to remove what they thought was wrong about their customary criminal law. And in the north, where that was predominant, you will find provisions in the penal code that try to extend those sentiments. For example, you find provisions in the penal code that punishes adultery. The woman doesn't think that adultery is an okay. The woman doesn't think that consumption of alcohol is an offense. But when they now enact this type of offenses, they introduce legal pluralism there by putting clauses that will tend to show that it will not apply on the territorial. For example, you say that the crime of adultery can only be committed by a person who originates from a community that forbids adultery. Okay? The meaning is that not all people can be tried for adultery. So they have introduced pluralism into criminal law with regard to the offense of adultery. Or you provide that The offense of intoxication is only a crime for a person whose faith or community forbids him from consuming alcohol. What have you done? They've introduced legal pluralism because not all persons will be chargeable for that offense. You will then be charging people on the basis of either their religion or their ethnicity. So any aspect of law where you find differential on the basis of either ethnicity or religion, legal pluralism is operating there. So you had legal pluralism operating in criminal law in northern Nigeria because the colonial masters tried to defer to the strong sentiments of the northern people. Okay, it was that the Sharia thing built upon. Okay, the colonial master had indirectly abolished personal system of criminal law as a general rule when it makes provision in the constitution that nobody shall be guilty of an unwritten crime. Okay, so and that is the reason why in order to allow Islamic or customary sentiments to be the basis of criminalization in the north, they have to put it in it. But the only thing that would not make it constitutional is the provision that abolish unwritten criminal law. So that's what they had to do. That's why in the north, pluralism operated in some area of criminal law, while in the south, criminal law was territorial. You will not be able to charge Mr. A for an offense of which Mr. B will not have been guilty, not in the south. So it was that the Zamfara model built upon. And so when the challenges came, the Zamfara model proponents and those who followed it defended by saying, well, we have not violated any law. What the Constitution said was that nobody would be guilty of an unwritten crime. And we have prescribed this in writing. Okay? The sentiment which the colonial master recognized, he did not recognize it deep enough. And we are going to extend the recognition more deeply. But there were other issues. The other issues, which are the issues of human rights. Okay? There were issues of human rights and all of that. Okay, like people argue that right to human dignity, which is an overriding provision in the Constitution, would have been breached if you start cutting people down. And I think the case went to the Supreme Court, and either Zamfara or one of the states lost that case on that basis, on the basis of the Islamic punishment being violative of the Constitution and all of that. Okay? So, you need to know the subject areas where it operates. Okay? Personal system will operate in any subject where personal consideration or personal sentiments based on ethnicity or religion. We are not being racist here. Is the whole reason why two people in the same territory, they are amenable to different laws. Then you say there's legal pluralism in that subject area. And the operator of legal pluralism is very practical. They gave the example of marriage. Yes, it's very practical. It is the legal pluralism operating in the area of marriage. The reason why A will marry B under the Act, but C will marry D under Islamic law, and E will marry F under ethnic customary law. That is the proof that legal pluralism operates in that area. And each of the three marriages will be valid according to our law. Now, one is not superior to the other. So it's not a question of normative hierarchy. But the problem usually is a problem of choice. Choice. Some of the time, a person who is amenable to a personal system, because there is no law forbidding him from opting out of it and becoming amenable to another one, the court will find that he has opted out of the one he's ordinarily amenable to, and he has become amenable to another one. So, example, even natives, they had the option of marrying under their native customary law. If they do it and that's all they did, they are validly married. Okay? But if they decide the next day to go to the registry to meet the requirement of the Marriage Act, okay, they have opted out of customary law, which they have a right to do, and become amenable to the statute. So everything relating to that marriage, the prescription of the statute is what the court will apply. It is not because the statute is superior to customary law. It's because the couple have chosen the statutory way of life to govern their affairs in that area. So, amenability, choice, and opting out. You have to be familiar with that. That is the rule that the court should apply. Okay? That is if they understand the subject very well. Okay? Another example I will give you is both Islamic and customary laws permit polygamy, but in different manner. Islamic law permits polygamy, but the man must not have more than 4. So I asked you a question as a conflict expert. I said, Alhaji Kabiru has taken a 5th wife without divorcing any of the first 4 wives. Okay? Explain the status of the 5th wife. Who can answer that question? Alhaji Kabiru, a native of, a Muslim native of Ogumoshi or Iraqi, has taken a 5th wife without divorcing any of the first 4 wives. Explain, suppose you are a judge, and you have to explain the status of the 5th marriage. How do you go about it? Yes, how do you go about it?
Under Islamic marriage, the 5th marriage is invalid. Invalid.
Yes.
Until
Please listen to him.
Until he purges himself of the legality.
He doesn't want to divorce any of the 4 wives. He wants to enjoy them. Oba Adeyemi Alaafin married more than I think the day he had maybe 10 or 11 or 12, isn't it? But I'm sure it's also an analogy. He calls himself an analogy and a Muslim. So he was a Muslim, I mean. He was a Muslim. And I like it to be precise. But Islamic law, if it was Islamic law he was following, he was not supposed to do more than 4. But he has done 12.
Is an ability to change because he has opted out of what the fifth.
So it's a question of choice. They are choosing customary law. Well, it's amenable. The issue is that it's amenable to both customary law and Islamic law. So we will look at personal characteristics to determine which of the two we has opted for. But you find courts, they will now use territorial tests. We are so I don't know what to call it about this tendency. Oh, they will say, he's from your Islamic law does not apply on you. It is not the question of tendency. It's the question of personal fact. If an Igbo man is a Muslim, they are not going to use, is a Muslim and has opted for Islamic law, which is available to by choice. They are not going to use Abakaliki native customary law to determine the validity of the transaction. You are going to, first of all, you must approach the issue with the mentality of if this relationship can be saved under any law that this one is amenable to, then it is saved. Because what we are now going to say is that the man opted for that as his choice. So, in this example I've given, the Muslim Alaji who married a fifth wife, for purpose of his marriage, he has opted out of Islam. So you cannot invalidate the relationship and send the unlucky fifth wife to be on her own. You must save the marriage if there is any basis that the man can be amenable to it. So you will not say that he's a Muslim. And that is the problem I have with the judgments from our northern courts. There's a particular case. Somebody just gave it to me. Where the Kwara State, United State has this law on the inheritance. What do we call it? Administration of estate law. And the provisions are uniform. They are all copied. They are the colonial master's policy, which is that if a man, they prescribe some rule of primogeniture that entitles the wife to inherit the husband, and the husband to inherit the wife, and the children to be the one to inherit. But because they are not regulating the matter in a territorial way, they put it there that what they are saying will not apply to you if you married under customary law. So you now have people who have married under the act, which forbids them from taking a second wife. But subsequently, they illegally took another wife under either customary law or Islamic law. So in that particular case, the second and subsequent marriages were done under Islamic law, but the first one was not under that. Fortunately, that provision, the further equivalent of that provision, says that even if the woman was married under the act, the rule would not apply if the second marriage was Islamic law. That is what we call tyranny of the majority. Because Muslims are majority in a state like Kwara, they are able to remove Islamic marriages from the colonial policy to disinherit an afterthought marriage done under Islamic law with second, third, fourth wives. Because having opened your eyes wide open and follow the woman to the registry, they have opted out of Islamic law the purpose of your marriage and incident. That is the purpose of law implication. But the statute has helped children of second and third marriage only if the marriage are done under Islamic law. If they were done under customary law, the rule will still apply. Okay? So, the decision of the court to say that the children of the subsequent marriages will also inherit made sense because of the provision of the statute that especially this. But the question arose, Peter, as regard what was the implication of the man marrying under the marriage act. And I think counsel repeated my type of argument to say that he opted that on Islamic law. He opted that on Islamic law. And the incident of his marriage, including the right to inherit, will no longer be governed. That's the correct answer. But in this particular case, because Father State has said that will not be so, that presumption has been refuted. But that's what a judge whose knowledge of quantity of law is very sound should have said. But what did the court say? The court said, no, you cannot opt out of Islamic law if you are a Muslim, unless you cease to be a Muslim. What is the pluralism concern with whether you opt out of your religion or not? The problem that the court are trying to resolve is this particular transaction. What is the governing law? And they are not applying a territorial text. You will find the court, they will say, this is Ijebu now. Islamic law is not operating in Ijebu. Can you say Islamic law is not operating in Ijebu? Are there no Muslims in Ijebu? Do they not have mosques there? Do they not in their own Islam? Does their own Islam not have accompanying fiqh or Sharia? We have not started in this country. Our judges don't understand the subject. They do not understand this subject and they need to be told. Okay? If you go to the High Court of Justice in England today, and you say you are two Muslims, and Islamic law governs you, the High Court of Justice in England will apply Islamic law to resolve your issue. That's it, man. We have seen cases where the High Court of Justice in England would apply Jewish law to Jews. Because the question they will ask themselves is, what is the governing law of the relationship? And what we have in internal conflict or legal pluralism is that along with the amenability test is the choice option, the opting out option. So all of this is what the court will consider in determining which law will govern the relationship between the parties. Just like in private international law and interstate conflict, we talk about connecting factor. In place of connecting factor, that's the question they ask themselves. Amenability test plus whether or not they have been opting out. It is not their business whether you change the religion or not. But if you opted out of the religion for a particular, Adetoboka Yunusa is another very interesting case. I think I discussed that case with the jurisprudence class yesterday. Okay? What happened in Adetoboka Yunusa? A Muslim left a will. The will was in the English law form, compliant with the Will Act 1837. And contrary to the prescription of Islamic law, that it is not for you to exclude Quranic heirs or to determine their shares. The Quran has already determined it, and you cannot do anything about it. But this man left 3 children. Whatever was his problem with his son, he never left anything by his friend. And he gave all that he had left to the remaining 2 children. Okay, so the third went to court. What was his argument? My father had no right as a Muslim to share his estate the way he had done. What was the argument of the other counsel? His father had distributed his estate according to a law for the time being was, which is the Will Act. And since the Will Act is a statute to override Islamic law, which is at best customary law. In the lower court, Bello J, as it then was, accepted the argument of the excluded child, saying that his father had no choice. But as a Muslim from Umana, in the territorial northern part of Nigeria, he had no choice than to distribute his estate according to Islamic law. So he had no capacity to use the Will Act to be the basis of distributing of his estate. Because they are all arguing the same way. You understand? When the matter went on appeal, Bello J was reversed. And what was the decision of the Supreme Court? The Supreme Court decided that no, Islamic law, no Islamic law. Islamic law is not more than customary law. The Will Act is a statute. The statute, and there is a provision that customary law, when it is incompatible with any law for the time being enforced, is not valid. So to the extent that Islamic law prescribes something, and the Will Act allows the breach of that thing, to that extent, is Islamic law invalid. Okay. In a conflict class, we will tell you that both of them were wrong. Why were both of them wrong? Both of them were wrong because the question before them was, what was the governing law of the dispute? It is true that the man was amenable basically to Islamic law, but you must not ignore the fact that he has the choice to opt out of Islamic law for the purpose of his inheritance. And he demonstrated that by doing a will. So the basis of upholding his wishes in his will be application of the test of amenability plus the right to opt out. So if the matter has been looked at from that perspective, now look, this is a question of personal system. Our law permits pluralism in the area of wills and capacity to make will. Okay? So a Muslim will basically be amenable to Islamic law. But if it is clear that he chose the statutory law which is equally amenable, which is equally applicable to him, so be it. The court will find out. It's just like compare it with personal law. We say the test of amenability for personal law is domicile in common law countries. But domicile can change. If the propositor acquires a different domicile of choice, we will apply that domicile to it, even though the test is very difficult to remember. So in the same way, if a person under legal pluralism who is otherwise amenable to customary law demonstrates clearly that for the purpose of a particular transaction, he has opted out, the court must recognize that. Do you understand? So, and unlikely who marries a fifth wife. Marriage is not a nullity. They are likely opted out of Islamic law for the purpose of that marriage. That's what happened. He was basically amenable to Islamic law, which would have prevented him from marrying a fifth wife. But because he's also a native, and customary law permits him to take a fifth wife, he has exercised a preference. He has opted out of Islamic law for taking customary law. In that way, you are saving the marriage and not putting the otherwise fifth wife into unnecessary jeopardy. Okay? So that is the way to look at the issue. Yes?
This thing, let me start from the statutory marriage. Said that there's a possibility of choice. So if somebody who contracts statutory marriage subsequently marries another, is that an automatic choice? That's
not a choice. That is a criminality. That's an illegality.
Okay, so
with his eyes wide open, he went into a system of law, a system of marriage that forbids him from taking second wife. So, in second marriage, there is no basis of validating the second marriage. But what he should have done was to undo what he did. Go to the court and notify that next marriage, so that you now become. Conflict. Now, governed by the common law system, the received English system, which would include the marriage act, the administration of estate law. What have you? You did not opt out of the statutory marriage and its consequences. And so the other woman is able to insist. You know understand?
So it therefore means that the liberty of choice does not extend to statutory marriage. So
what it does mean is that whereas you have the latitude of opting out, so that your subsequent transactions can be governed by another personal system of law. In this particular instance, he has not opted out. In most of the cases where that become an issue, the act marriage remains of 60. on the demand less. So if he wants to govern his affairs very well, before he goes into a marriage with another woman under customary law, he should dissolve the one he had with the woman under the marriage.
So if you want for customary, if it's customary marriage, there's no need to officially dissolve. You can go ahead, or if it's like
If it is Islamic marriage he had first, he had marriage with gay on it.
no, I'm saying if he has Islamic marriage up to 4, and then he's married with 5th person under customary law, there's no requirement to effectively dissolve Islamic law marriage.
If you want to do it under Islamic law will permit him to dissolve one so as to replace one of the women.
No, but you said that because he did not divorce one of the women.
If you want,
he has opted out of Islamic marriage into customary law.
Yes, because customary law will save all of the prime marriages.
But that fluidity is now available if the first marriage is a statutory marriage. That's what I'm saying.
Yes, once we married under the act, and it is a provision of the act itself. The consequence of that marriage is that I cannot marry another woman. So he will have to opt out of that marriage first if he now decides to be a polygamist. Do you understand?
I get it. The second question I just want to ask. You said that if the person opts out, you're giving an example that the person opted out of Islamic marriage in relation to that 5th marriage. And so the court should consider that the marriage is not a customary marriage, and then
all of the 5 marriages will be changed under customary law, and they will have a hospital.
So if we are now looking at choice with respect to the validity of the 5th marriage, does it now extend that choice? Since you have not left Islamic law marriage, does it now extend that choice to also succession of the immovable? So that
of course,
that Islamic law now.
There is something about the people we don't have time. There's something about status that I used to use company law to explain. That every subject area of status begins from marriage. All of them are related to marriage. Legitimacy is a function of the type of marriage you claim. Legitimation is a function of the type of marriage you claim. Islamic law, for example, does not allow legitimation. So, if your mother and your father were married under Islamic law, but you were born before the marriage, and you go to heaven with that thing. Because Islamic law has no provision for you. Do you understand? Huh? That's customary law. There's nothing like that under Islamic law. No, what I'm saying that if a person's father and mother were married under Islamic law, okay, but he was born before they married, Islamic law has no provision for legitimation. Do you understand? So whether he will ever be regarded as legitimate or not will depend on the marriage his parents have. Whereas if his parents chose the act marriage, he is already automatically legitimated by that marriage. If it is customary marriage his parents have done, even in ordinary acknowledgement of the man is enough. So legitimation is a function of marriage. Legitimacy is a function of marriage. Succession is a function. All of the other issues, you must relate them back. So I normally give an example that is like, if you are an analyst and you analyze very well, you will see that everything you learn in company law is premise of corporate personality. So corporate personality is one principle you cannot remove from company law, and you still have company law. In the same way, all of those other issues, capacity to make with legitimation, succession, they all derive their roots from marriage. So the type of marriage you enter into is one And that's why the matrimonial, that's why the state inheritance laws we give administration of residence will give you the rule and say, but this rule will only apply because they know it will not be of no relevance. This is another marriage that the proposals are. It's really very logical if you train yourself to understand it.
I was just trying to find out the exact rule that we apply. It must be an overt act. The person show that he has moved religion from this, or he has moved applicable law from this to this, or there's just a presumption based on
evidence will be given, and the court will be able to say, look, just the same way that evidence of everything about the life of the propositors will have to be given before the court will identify that he has acquired the needles. The same way you will give. Okay? There's an article of mine you will read on this issue, especially the friction between Islamic law and customary law in Southwest. There are several cases of Muslims whose inheritance became an issue before the court. But the court will go on and apply the wrong thing. Oh, it's from Ijebu. Islamic law doesn't apply in Ijebu. That's not correct. That's not correct. You cannot mix territorial test with personal test. Do you understand? If the propositor was a Muslim who was equally amenable to customary law, you study the facts presented to you and see which one does the story of his life tell. Do you understand? So our Alaji, who because of his love for women, took a fifth wife under customary law. Whichever way you look at it, the story of his life, I said, he may be a Muslim, but for purpose of his marriage, he opted out for Islam. Our other Alaji, who, despite knowing full well that as a Muslim, he had no right to exclude one of his children, was so annoyed with the child, and the Islamic law principle did not cool him down. And he then did a will which everybody has right to. The court just fine. Yes, he was amenable to Islamic law, but for the purpose of succession, he opted out. What is difficult in doing that? There's a case, Amina to Allah, you are Towashi. Okay? One of the cases that I analyzed in my article. The woman died without leaving a child. Okay? And Islamic law permits spouse to inherit one another. Only that the male spouse will get twice what the female spouse will get from the male spouse. So, in that particular case, evidence was led to say that this is the position of Islamic law, and her husband was supposed to inherit. He married, he was an Elijah, he married the man under Islamic law, they lived as Muslims. Though, when she attained a certain age, because she was the driving force of the marriage, she lived in a house of her own, even when the man had to marry other women to have children and all of that. But there's no evidence that they dissolved the marriage. So, when evidence was tendered to say that in this type of circumstances, both of them were Muslim, their marriage was in Nikah, succession to be governed by Islamic law, the man is entitled to marry. The answer of the court was that Islamic law is not operating in the way. What type of criteria is it? What type of criteria? What criteria is it using? Okay? Even when I've arrived at the same man side, he's able to find that maybe the woman opted out of Islamic law. with regard to his test it. But you have to have evidence. So at the end of the day, he decided that she didn't have children. Collateral relation from her own parents are the ones that we inherit. Excluding the husband, that's not the devil custom. The devil wives, their husband don't inherit them, especially when there are no children. None of that. So that's how he decided the matter. And I said, he has simply decided the matter using a territorial test. But when you are talking about legal pluralism, the test of amenability and opting out is supposed to be a personal one, not a territorial one. No, those and survey have to do with the conflict between the civil English law and customary law. Okay, so that's what we are saying. The test is amenability, and the court to check whether there was an opting out of the system of law to which the proposal would have been amenable. So that yes. Well, Islamic law, I'm not an expert in Islamic law, but there is a provision that permits 1/3 for collateral relation. Am I correct? Those of you who have attended universities in the north, there is a Islamic law has this provision of not more than 1/3 of your estate. You can use it to take care of those your extra baggage. Do you understand? But nothing less than 2/3 must be distributed according to the Quran. That's Islamic law. So what makes the case bad in Hadith was that it was a Quranic care that was being denied. Okay? It was being denied contrary to the fact that I think all of the 3 children were made. They ought to share equally. There is no issue when they are all made. When you have made a female, they should want to keep. That's Islamic law. But the question before the court is, what is the governing law of that dispute? That's the question before them. If they had looked at it with a conflict of laws mind, they would have seen that, yes, Islamic law, the man was amenable to Islamic law, but he wanted that of it. Just like acquire a Nigerian domicile of choice or of origin, and they acquire a Beninese domicile of choice. Do you understand? So, I said pluralism will throw up 3 questions. The first one is amenability. The second one is change. When do you recognize that there is a change? Change by opting out and change by other means. This one, you don't. Normally have but as a company president, inheritance cannot start the root. It takes its root from money. Do you understand? So in the Olowo and Olowo case, the man had married Benin women and lived in Benin, did a lot of things. In fact, because he wanted to acquire land in Benin, he went to the Oba, and the Oba naturalized him, quote and unquote. Even the Supreme Court recognized that that will not happen today. Because of Section 43. of the constitution. You can acquire land anywhere. So nobody can give you precondition for acquisition of land. You can't be treated as an alien anywhere in Nigeria with regard to acquisition of land. So what they had to do at that time would not have been necessary to do. One of the Supreme Court justices noticed that. But the real issue there was whether it became amenable to the customary law because of the facts. Because they were using all manners of principles. One of them used estopel. Okay. Another one said he has become, he has acculturized. All sorts of terms. So go and read that thing. But at the end of the day, they agree that his inheritance became subject to the customary law. You see the formula? It is the propositor's personal system of law that the court was looking for. After accepting that it was originally amenable to the customary law, they recognized that there has been a change. He had by choice changed to the customary law. Okay? Then the third question that legal pluralism will throw up is the normal question we answer every day in the conflict of laws, which is that we are amenable to Yoruba customary law. I am amenable to statutory law. We transact. What is the governing law of the transaction? That's the one that the Icon laws try to solve by giving you presumption. But because they gave the presumption on the basis of territory, the answer will always give problem. Why do I say that they gave the answer on basis? They say that two Nigerians or two natives, if they transact, the presumption is that customary law will apply. One native and non-native, if they transact, the presumption is that general law will apply. Then, between these two general rules, we now try to say, give you how you can report the presumption and all of that. But the problem, there's a lot of problems with those rules. I've done an article saying that most of the issues that will arise under personal system of law, you can't categorize them as transactions. And the rules are couched. Those Icon laws are couched in the form of a transaction. So you want to discuss inheritance of somebody's estate. How can those you say, who transacted with you? So I said that the only aspect of personal status law that look like transaction is marriage. But even that one is a status transaction. There's a difference between a transaction and ordinary transaction and a status transaction. In a status transaction, the society prefix the rule. In an ordinary contract, the parties speak the rule by themselves. Okay? So, and all of the other ones, legitimate or succession or capacity of people, they derive from that marriage. So, I said, those High Court laws provision are useless. For most of the issues that will arise, they are useless. And when the courts rely on them, they will always get the answers wrong. Take a case like Fonseca and Pass. Fonseca and Pass was the case where a Portuguese married our own daughter here. I think, an Ibibio girl. Is it Ibibio or Efi? Okay? Ibibio or Efi, he said that at one time, half of the children born by Ibibio or Efi television were born to Europeans. Okay, so you will see that they always have mixed color. They are not always black, none of that. Okay, but in that particular case, the question was the right of the child of that marriage to inherit the father. And the Nigerian court, sitting in Nigeria, trying to use these misleading rules of their law, say that because the marriage was a transaction between a native and non-native, the presumption is that it's governed by foreign law. And so, since the marriage would only be valid if it is regarded as having the law of other customary law, the Portuguese man had no capacity to marry under customary law. And so the marriage was a nullity and the children could not inherit. You see legal system people trying to criticize that case. They don't know how to do it. They need the knowledge of this subject area to know how to do it. The case was not a case of internal conflict. The case simply was not a case of internal conflict. How do we describe private international law? We say there must be foreign element. What of internal conflict? There is no foreign element, but it is the legal system of his own that has permitted personal system of law. So if the husband was a Portuguese, there's a foreign element. It is the private international law rules that the court ought to have used. And if they had used the private international law, they wouldn't have arrived at that decision. When we get to marry, we analyze that case for you in the light of the private international law rules related to it. But they try to use those presumptions in their column. And it's got it wrong. Okay? Let me go. So, what I'm going to do, I'm going to use your paper to do the student class, their own. I'm going to give you a number of articles that you have. What is our issue? Our issue simply is that a matter is before the courts. It is not a conflict of law issue because there is foreign element, but it is a conflict of law issue because it is in a subject area where operate legal pluralism. And so the court might be faced with the task of which one do I use to determine this case? Is it damage law? Is it customary law? Is it statutory? Okay? So they should understand the test of amenability, and they should understand the issue of opting out or changing the law that you are amenable to. And then, if it is a simple case of people belonging to two different personal systems of law interacting, just like the same way that they will find the governing law of a dispute with one element, they should find the governing law of this one too. Everything will then depend on the facts and the evidence. Okay? And if you are going to use the presumption should be logical. For example, if the female spouse belongs to a particular ethnic group and the male spouse belongs to another one, okay? I will be interested to hear a judge say, well, in Nigeria, you marry according to the wife's personal law, but the marriage is governed according to the husband's personal law. So if the reason why they say there is no marriage is that something has not been done, which needed to be done under the wife's customary law, I expect the court to say, yes, that is the law that ought to govern that issue. You cannot go and marry Miss A, not complying with the law of our parents. Do you understand? On the other hand, if it is the woman that is claiming incident of that marriage that is unknown to the husband culture, I expect the court to say, well, you married him. You married into your husband's culture. You cannot claim a right which is not incidental to marriage as not to your husband's culture. Logical, but sound. Do you understand? You will see that when we get to marriage under private international law, that is basically what the courts do too. We'll be telling you that, look, certain issues will be governed by domestic, certain issues will be governed by lex notice and repetitions, and everything will depend on the ground upon which you are forcing the marriage. Okay? And something I didn't discuss with you, which would have been a very correct thing, the issue of the Sharia panel that our courts, our government in the Southwest are complaining about. Okay? We will have another day for that one. After explaining to. Okay. Okay. So, no, how are you?
Ese è quello che vuole bene. No, ma c'ha mi ò máa tiẹ̀ wá ṣe nígbà tẹ̀ wá jẹ́ kókò wá mọ gbogbo ẹ̀ ṣùgbọ́n ṣàǹbáyàn kan rìn látijọ́ ẹ̀. Àwọn tá à ń bá tẹ́ bá rí yìí kọ́ ló ní brown level kí ló papọ̀ mọ́ green tó papọ̀ mọ́ orange.
Kò dání tó wò yẹn.
Ó wò ó.
He did put on a cap.
Who will ask you?
Answer, yes.
Who will ask?
He did.
Obìnrin ká fi ẹsẹ̀ wá gbogbo ìṣẹ́ bá wà mọ̀ wá títí. Èmi ò mọ ọgbọ́n bá tó wà lé sábì ká dáhùn sọ̀rọ̀. Ọmọ tẹ fẹ́ mọ́ dàrí. Gbogbo ẹ̀ sọ gbogbo ẹ̀ tó ṣe gbogbo ẹ̀ sọ gbogbo ẹ̀ sọ ẹ̀ sọ ní àyè àyè. Ọ̀rẹ́ mi wà ní kíláàsì mi lè ṣe dé. Àmì ìlú ọ̀sẹ̀ láti lọ.
Ẹ̀túnṣú. I'm sure.
Ẹ kúrò jàre.
Ọjọ́ pé ọ̀nà wí.
Pass. And not see pass. And Wasila, Wasila. Ó mọ̀ pé ogún ìjọba kò gbé omi tó lè pè ṣé wà gbígbé kí ló ń ṣe kó lè concentrate àdó tẹ̀sí bí kò ń di fóònù kiri báyìí. Ṣé àwọn skẹ́ẹ̀tì ọ̀rọ̀ yìí náà ló skẹ́ẹ̀tì tó ń fi kíní gbọ́ ìdílé. Ìyàwó nù ọ̀dẹ̀ ọgbà àwọn onískẹ́ẹ̀tì skẹ́ẹ̀tì pàṣàpàṣà. bóyá plus. Ẹ̀ka padà sí báàgì mi láàárọ̀ yìí, wọ́n á dé wọ́n á wá plus. Okay. Okay. Oh God. I want to mind the little bit, but don't you are when you are when you are funny.
Oh, serious.
Break. Not break. Don't worry, Baba. Sorry. Okay, more yes. Okay, I'm gonna look for their woman. Okay, sorry. Eh? Sorry. What the I will not say? Come.
láwọn ó ní kí wọn láwọn láwọn.